The marble columns of the United States Supreme Court carried the echo of a collective gasp from the audience. Associate Justice Samuel Alito, long admired and criticized for his rigid conservative philosophy and sharp-edged questioning, had just mocked Congresswoman Jasmine Crockett before a national audience. "Congresswoman," Alito drawled, sarcasm dripping from every syllable. Perhaps constitutional law is taught differently in Texas, but that's certainly not how this court has ever understood the First Amendment. A ripple of laughter spread through the chamber. A few clerks exchanged uneasy glances. Even some of the other justices shifted in their seats, surprised by the bluntness of his tone. At the podium, Congresswoman Jasmine Crockett, representing the plaintiffs in a landmark voting rights case, stood poised and still. The comment was meant to rattle her, to undermine her authority. Instead, she waited, silent for half a heartbeat, then lifted her gaze. "Steady as stone, Justice Alito," she said, voice level but strong. "If I may, I'd like to draw the court's attention to our supplemental brief. Appendix C, page 14. What followed silenced the entire chamber. Time may. Documents she was referring to didn't merely answer the justice's critique. They redefined the constitutional foundation of the entire case. Before breaking down what she had uncovered, it's worth recalling why this case mattered so deeply. The court was hearing Martinez versus State Elections Commission, a pivotal challenge to newly enacted voter registration restrictions. The question at stake: could nonprofit organizations be legally required to register with the state, disclose their internal operating structures, and send every volunteer through state-mandated training before they were allowed to help citizens register to vote? The stakes were national. 17 states had already enacted similar laws, claiming they were essential to prevent fraud. Civil rights groups, however, argued the opposite, that these policies strangled the ability of local, often minority-led organizations to reach disenfranchised voters. Justice Samuel Alito, appointed in 2006 by President George W. Bush, was a staunch originalist, famed for his strict textualist readings and his belief in limited federal interference. Before joining the nation's highest court, he had served as a U.S. attorney and later as a judge on the Third Circuit Court of Appeals. His courtroom style was relentless, analytical, skeptical, and razor-sharp. The ideological contrast could not have been clearer. Congresswoman Jasmine Crockett, representing Texas's 30th District, came from a very different legal tradition. A former civil rights attorney specializing in voting rights litigation, she blended constitutional interpretation with historical perspective and real-world data, grounding her arguments in lived experience. The court's decision to allow a sitting member of Congress to personally argue before the justices was unusual, signaling just how significant this case had become. Lower courts had been deeply divided. One appellate panel had struck down similar voter registration laws as unconstitutional violations of free speech and association, while another had upheld them as reasonable exercises of state power. That judicial split forced the Supreme Court to step in. Most analysts predicted the conservative majority would side with the states. The early arguments played out along expected lines. Conservative justices emphasized state control and election security. Liberal justices focused on the chilling effect these laws had on civic organizations. But the tone in the courtroom shifted the moment Crockett began to speak. Instead of relying solely on the First Amendment, she traced the historical roots of voter registration drives, describing them as acts of political association protected not just by the First, but also by the 14th Amendment. She provided data showing that the new regulations placed disproportionate burdens on small, minority-serving organizations. These statutes don't just set administrative rules, Crockett explained clearly. They give state officials the discretion to decide who can help citizens register to vote, and who cannot. That power, history shows, has often been used to silence minority voices. Her reasoning drew the attention of Justice Elena Kagan, who leaned forward with interest. "Congresswoman Crockett," she asked, "are you suggesting these laws warrant strict scrutiny because they implicate both associational and voting rights?" "Yes, Justice Kagan," Crockett replied without hesitation. The historical record makes it unmistakably clear that community-based voter registration drives have been essential in expanding access to the ballot, especially for minority communities. These new restrictions directly target those efforts while leaving other political activities untouched. It was then that Justice Alito leaned back in his chair and prepared to strike. "Congresswoman Crockett," he began, voice sharp with skepticism. "You're arguing that these regulations require heightened scrutiny because they supposedly affect certain communities. Yet the laws are facially neutral. They apply equally to all organizations conducting registration drives. There's nothing in the text that singles out any particular group." Crockett nodded respectfully before responding. "Justice Alito, while the language may appear neutral, the implementation is not. The evidence in our record demonstrates how these rules disproportionately impact small, community-based organizations operating in minority neighborhoods." Alito cut in quickly, not unusual for him. "Many laws produce uneven effects," he said curtly. "That alone doesn't make them constitutionally suspect. Election regulations always burden some organizations more than others. That's not discrimination. It's governance." "With due respect, Justice Alito," Crockett replied steadily, "our argument isn't about statistical imbalance. It's about continuity, a pattern that connects these modern laws with a long history of suppressing community-led registration efforts in marginalized areas." Alito's tone turned clipped. "Historical context doesn't transform a neutral statute into a discriminatory one. This court has consistently evaluated laws on their current terms, not through the lens of practices that no longer exist." The tension in the courtroom was palpable now. Several justices exchanged glances. Crockett remained composed. "Justice Alito," she continued, "our evidence isn't ancient. We have legislative records from the past 2 years, showing sponsors explicitly discussing how these regulations would limit organizations working primarily in minority communities." Alito arched an eyebrow. "Legislators discuss impact all the time. That's politics, not proof." Crockett didn't flinch. "Our position aligns with this court's precedent in Meyer versus Grant," she said firmly. That case affirmed that petition circulation constitutes core political speech entitled to the highest First Amendment protection. Voter registration drives fall into that same protected category. That was when Justice Alito made the remark that would set social media ablaze and dominate headlines for weeks. "Congresswoman," he said with thinly veiled condescension, "perhaps they teach constitutional law differently in Texas, but that's not how this court has ever read the First Amendment. Meyer dealt with direct political advocacy, not administrative registration. States retain broad discretion to regulate the latter under Article 1. A faint laugh rippled through the courtroom. Clerks shifted uncomfortably. Even a few of Alito's colleagues looked uneasy. Jasmine Crockett didn't waver. Her eyes stayed fixed on the bench. "With respect, Justice Alito," she said evenly. "Please turn to Appendix C, page 14. A soft rustle of papers spread through the courtroom as the justices flipped to the referenced section. "This appendix," Crockett continued, "contains internal communications from the State Elections Commission obtained through discovery. The highlighted email is from the Commission's own legal director to the bill's sponsors, sent just 3 weeks before the legislation was introduced. The atmosphere changed instantly." Justice Sonia Sotomayor looked up sharply. Justice Brett Kavanaugh furrowed his brow. Chief Justice Roberts studied the document silently, jaw tight. The email read, "The new registration, training, and operational plan requirements will effectively prevent most community organizations from conducting voter registration drives." The courtroom went still, and the marble itself seemed to absorb the gravity of what had just been. Read, "This will be particularly effective in reducing registrations in targeted urban and minority-heavy districts where such drives have historically generated thousands of new voters unlikely to support our preferred candidates." The courtroom fell silent. Even Justice Alito's expression had changed from dismissive to intensely focused as he continued reading. The next page contained the Commission's internal analysis, confirming that nearly 85% of the organizations unable to meet these new voter registration requirements primarily serve minority communities, Crockett explained. Turning to the next document, she continued, Page 16 provides a district-by-district breakdown showing the steepest declines projected exactly where minority populations are highest. Justice Elena Kagan leaned forward. Congresswoman Crockett, was this evidence presented to the lower courts? Only partially, Your Honor, Crockett replied. The most revealing communications were uncovered after the appellate decision. Our ongoing discovery revealed that these internal analyses had been deliberately withheld during the original proceedings. We filed a motion to supplement the record, and it was granted because of the new evidence's importance. Justice Alito had regained his composure, but now seemed more careful. Counselor, he began, even assuming your representations are accurate, these communications reflect the opinions of commission staff, not necessarily the legislature that enacted the statute. Crockett was ready for this. Justice Alito, she said confidently, if you turn to page 18, you'll see text messages between the commission's director and the bill's sponsor. The sponsor's reply reads, "This is exactly what we need." The beauty is that nothing in the text explicitly mentions these communities, so it should survive legal challenge while achieving the desired outcome. Justice Amy Coney Barrett, who had remained silent up to that point, joined the questioning. Congresswoman, this evidence certainly raises concerns about intent by certain officials. But how do you respond to the state's argument that regardless of improper motives, these regulations still serve legitimate interests in election administration? That question opened the door for Crockett to strengthen her broader constitutional argument. Justice Barrett, she replied, this is exactly where the First Amendment becomes critical. When a law burdens political rights like association and expression, it must be narrowly tailored to serve a compelling state interest. The state's stated goal administrative efficiency can easily be achieved through far less restrictive measures, she continued, her tone steady and persuasive. Moreover, these internal communications show that efficiency was never the real motive. The evidence demonstrates that officials intentionally designed these requirements to suppress voter registration in specific communities. That makes this not just a matter of bad policy. It's a constitutional violation where administrative rules become tools for viewpoint discrimination, something the First Amendment explicitly forbids. Justice Alito, now fully engaged, posed a new question that signaled a remarkable change in tone. Counselor, has said, if we assume your evidence accurately reflects legislative motivation, how would you have this court craft a remedy that corrects the constitutional violation while still allowing states to regulate voter registration? This question focused on remedy, not resistance, marked a turning point. Alito was no longer dismissing Crockett's expertise. He was actively engaging with her constitutional framework. Crockett answered with precision. Justice Alito, the court could apply the Anderson verdict standard. Under that precedent, any regulation that severely burdens political participation must be narrowly tailored to serve compelling state interests. When administrative requirements selectively target specific communities without genuine necessity, such rules should be presumed invalid. She paused, then concluded firmly. This approach preserves state authority to regulate elections, while preventing the misuse of that power to suppress political participation. It also provides clear guidance for lower courts in evaluating similar laws in the future. As her time expired, Crockett had done what few advocates ever manage. She shifted the entire tone of a Supreme Court session. Through meticulous command of the record and constitutional doctrine, she turned skepticism into serious consideration. Even Justice Alito, who had once dismissed her argument with condescension, now treated it with respect when Chief Justice Roberts thanked her. There was a quiet recognition among those in the courtroom. They had just witnessed something rare, a moment where truth, evidence, and advocacy changed minds in real time. When the state's attorney rose for rebuttal, the courtroom dynamic had completely changed. Justices who once seemed ready to defend the state's position now pressed hard on its credibility. Counsel Roberts began, "How do you respond to the emails showing the commission designed these requirements to reduce voter registration in minority communities?" The attorney hesitated. Mr. Chief Justice, those communications reflect only the personal opinions of staff, not the official stance of the legislature or the commission. Justice Brett Kavanaugh immediately followed up. But the text messages between the commission's director and the bill's sponsor explicitly acknowledge a discriminatory purpose and even celebrate how neutral language conceals. How can we ignore that? Justice Kavanaugh, the attorney stammered. Isolated communications don't represent the collective intent of the legislature. Then came the question that sealed the moment from Justice Alito himself. Counsel, he asked, even if we set aside legislative intent, doesn't this evidence at least create a strong inference that viewpoint discrimination played a role? And if so, wouldn't that trigger heightened First Amendment scrutiny under this court's own precedent? It was a stunning reversal. The very justice who had mocked Congresswoman Crockett's First Amendment argument less than 30 minutes earlier was now echoing it. His words reflected not dismissal but respect for the legal framework. She had so powerfully established the state's attorney quickly, understood the significance of this sudden shift. Justice Alito, he began even if certain officials acted with improper motives. These regulations still serve legitimate state interests. Their purpose is to ensure accurate and secure voter registration. This court has long held that facially neutral election laws deserve differential review. Justice Elena Kagan immediately seized on the point. But that's exactly what Congresswoman Crockett argued. She countered. When the record shows that neutral wording was deliberately used to hide discriminatory intent, doesn't that fundamentally alter their constitutional analysis? Even Justice Clarence Thomas, who rarely speaks during oral arguments, joined in counsel. He asked, how do you reconcile the Commission's internal projections, showing these rules would reduce registration by over 80% in predominantly minority districts, with your claim that the burdens are incidental? As the questioning continued, the courtroom atmosphere changed entirely. The documents Crockett had presented reshaped the justice's understanding of the case. Even those who initially favored the state's position now focused sharply on the evidence of intentional discrimination and its constitutional impact. By the time arguments concluded, legal analysts were already predicting that the court might issue a sweeping ruling against discriminatory voting restrictions, something few had expected from the current conservative majority outside the courthouse. Reporters crowded around Congresswoman Crockett. The first question was inevitable. How did she stay calm when Justice Alito mocked her credentials? My focus wasn't on personal remarks, she replied steadily. It was on ensuring the court engaged with the facts. The documents speak for themselves. They turned an abstract debate over state power into a concrete case of intentional discrimination, precisely what our Constitution forbids. When asked about Justice Alito's apparent shift during the hearing, Crockett was poised and professional. Once the evidence weighs on the table, Justice Alito asked thoughtful, substantive questions. She said, that's how the judicial process is supposed to work. Arguments should be tested by evidence, not assumptions. Legal scholars quickly recognized the day's significance. Harvard law professor Noah Feldman told CNN, what we saw today was extraordinary. A justice dismissed an advocate's legal theory, then adopted it once confronted with undeniable evidence. It proves that facts can reshape constitutional interpretation. At Georgetown University, Professor Paul Smith echoed that sentiment on social media. Congresswoman Crockett didn't rely on abstract doctrine. She directed the court to specific proof that changed the entire framing of the case. By that evening, the hearing was being hailed nationwide as a turning point. What had seemed likely to be a narrow affirmation of state authority now appeared poised to become a landmark voting rights decision. Legal blogs predicted that the court would rule that evidence of discriminatory intent triggers strict scrutiny even for facially neutral regulations. The exact argument Crockett had made. One prominent constitutional scholar summarized it perfectly. Justice Alito may have mocked Jasmine Crockett's legal training, but her mastery of the facts and the Constitution ultimately changed how the entire court saw the case. It's proof that evidence and precision still matter in the pursuit of justice. 3 months later, the Supreme Court issued its ruling in Martinez v. State Elections Commission in a stunning 7-2 decision written by Chief Justice John Roberts. The court struck down the voter registration rules as violations of the First and 14th Amendments. Even more surprising, Justice Alito joined the majority rather than writing or signing a dissent. The majority opinion cited extensively from the very evidence Crockett had introduced, establishing a powerful new framework for evaluating voting. Restrictions with discriminatory intent when plaintiffs present credible evidence that facially neutral voting regulations were designed to suppress identifiable groups. Roberts wrote, "Courts must apply strict scrutiny, regardless of administrative justifications. States have broad authority to manage elections, but that power cannot be used as a pretext for discrimination or political suppression." The opinion directly referenced the emails and text messages Crockett had revealed. Third contains disturbing proof that officials deliberately structured these requirements to reduce voter registration in specific communities based on perceived political preferences. Such motives are incompatible with the state's duty to uphold neutral and inclusive election processes. The court also established a new burden-shifting standard when plaintiffs present substantial evidence of discriminatory intent. The burden shifts to the state to prove that their regulation would have been enacted regardless of that intent, and that it is narrowly tailored to serve a compelling state interest. This new precedent, far more protective of voting rights than observers expected, had immediate nationwide implications. Within weeks, 16 other states with similar voter registration laws suspended enforcement, announcing reviews or revisions to comply with the ruling. Legal experts across the country hailed the decision. Yale law professor Heather Gerken called it a defining moment for American democracy, adding, "This ruling provides a practical tool to challenge laws that appear neutral but are rooted in discriminatory intent. It establishes that motivation matters, a principle that will resonate across all areas of constitutional law." For civil rights organizations, the decision became a legal breakthrough. The NAACP Legal Defense Fund quickly announced plans to challenge several election laws under the new framework. Focusing on statutes where documentary evidence revealed discriminatory motives hidden behind neutral language, the victory was not just legal, it was symbolic. Congresswoman Jasmine Crockett had faced skepticism and ridicule at the nation's highest court. Yet her preparation, composure, and command of the record-reshaped constitutional doctrine and reaffirmed the power of truth in the pursuit of justice. State legislators across the country quickly responded to the Supreme Court's landmark ruling. In states with pending election legislation, lawmakers revised their proposals to ensure compliance with the new constitutional framework. Legislative council offices issued detailed guidance warning that any internal communications revealing discriminatory intent could now invalidate otherwise lawful regulations. The message was clear. Election measures must be justified by genuine administrative needs, not political or demographic targeting. The decision's ripple effects reached academia as well. Law schools swiftly integrated Martinez, State Elections Commission, into constitutional law courses. Using the oral exchange between Justice Alito and Congresswoman Jasmine Crockett as a case study and how compelling evidence can reshape judicial interpretation. New seminars on evidence development in voting rights litigation emerged, underscoring how factual discovery can determine constitutional outcomes for Congresswoman Crockett. The ruling served as powerful validation of her legal strategy and advocacy. In national interviews, she downplayed personal triumph and emphasized the broader democratic principle affirmed by the court. This decision reinforces that our democracy cannot be manipulated through laws designed to silence specific communities. She explained, "When evidence shows discriminatory intent, courts must look beyond neutral language to uncover the true purpose and impact of voting restrictions." When asked about her now famous exchange with Justice Alito, Crockett remained composed and substantive. The focus was never on tone. It was on the evidence. She said, "The record revealed the real motivation behind these laws, and the court correctly placed that evidence at the center of its analysis." In a latter address to the American Law Institute, Justice Alito himself appeared to reflect on that transformation without naming the case directly. He spoke on the importance of judicial openness. Judges must remain willing to have initial impressions changed by evidence and argument. That flexibility is not weakness. It is the essence of sound judicial reasoning. Many observers viewed this as a quiet acknowledgement of how Crockett's factual presentation had shifted his own understanding during oral arguments. The Martinez ruling soon reshaped voting rights litigation nationwide. Lower courts adopted the new framework, giving unprecedented weight to proof of actual discriminatory intent rather than accepting facial neutrality at face value. Within a year, multiple restrictive voting measures were struck down, and a Brennan Center for Justice study estimated that litigation under the Martinez standard had restored voting access to nearly 1.8 million Americans. In classrooms, law professors replayed the oral argument to illustrate effective advocacy. "Watch how Crockett never takes the bait," one professor told her students. "Cher directs every dismissive comment back to constitutional evidence. That's precision, advocacy, anchoring, persuasion, and substance, not emotion." The Martinez decision also transformed how legal teams prepare Supreme Court cases. Top litigators began emphasizing the discovery of documentary evidence over purely doctrinal argument, recognizing that facts, when properly developed, can transcend ideology. A Sohn leading advocate wrote after Martinez, "Every serious constitutional challenge starts with evidence, not a rhetoric." Ultimately, the case demonstrated that constitutional law evolves through the interplay of evidence, argument, and judicial reasoning. As Stanford's Professor Pamela Karlan observed, Martinez proves that when confronted with undeniable evidence of discriminatory intent, justices across the spectrum return to first principles, the Constitution's guarantee of equal participation in democracy, the legacy of that extraordinary oral argument. Beginning with a dismissive remark and ending in a historic affirmation of voting rights, continues to influence both advocacy and judicial philosophy. As Georgetown Law Dean William Trina reflected, Martinez reminds us that constitutional interpretation is not static. It grows through courage, clarity, and the power of truth. If this story of evidence-driven advocacy inspiring judicial transformation moved you, don't forget to like and subscribe. We bring you the most consequential Supreme Court moments that show how facts, not ideology, shape constitutional history. Share this with anyone who believes in the power of advocacy, evidence, and democratic integrity.